First, thanks to Alan Baker in the back and the lawyers at Boss for allowing us here. Very much appreciated. If you are in the Inns of Court, or Inns of Court, we have our mentoring program that Judge Carroll spoke about earlier, and I encourage you all to do that. Judge Walsh, can you say anything about y'all?
Just happy to be here. I'm hoping, it looks like y'all have quite a few more members than we do. Perhaps we can join efforts in the future. I think this is a good program, and both of us pulling together I think is a good idea, and I'd like to promote that in the future. But delighted to be here. Thank you for this, and look forward to it.
One thing about it, and not here to preach, but particularly if you're still in law school, it also applies to the lawyers who've been here for a while. This is a great opportunity to get to know and become friends with lawyers that you may not practice with. If you want to know what it's like to be a federal judge, you have a chance to talk to Judge Otten. If you want to know what it's like to be a former president of the ABA, Tommy Wells is right here. If you've ever wondered about what it's like to be a federal public defender, Kevin Butler is in the back. Everybody here has a story, and they really want to share it with you. That's why they're here. So please take advantage of it. We don't have that many meetings, but we encourage everyone to come. Judge Carroll, I'll call on you if that's okay.
Sure. It's my pleasure to introduce this evening's speaker, Justice, now Dean Bill Koch. I met Bill back in about 8 years ago when I joined the Board of Trustees of the American Inns of Court. He's one of the real leaders in the American Inns of Court movement in the United States. And he has a very, very distinguished legal career. His undergraduate degree is from undergraduate degree is from Trinity. Now, the only people in this room that know about Trinity are Professor Alban, who went to Wesleyan, and me, who went to Tufts University. So we are arch rivals with the Wesleyan, what are they, Bobcats or something or other?
Wesleyan Cardinals.
I mean the Trinity.
Bantams.
The Bantams, okay. He then went to Vanderbilt Law School, became an assistant attorney general in the Tennessee system, then started work for Senator Lamar Alexander, where he served as legal counsel in various other capacities. And then he was nominated to the Tennessee Court of Appeals, where he served as the chief judge for many years, then appointed in 2007 to the Tennessee Supreme Court, where he served until 2014, when, without talking to anybody about whether being a dean was a fun life or not, he decided to become dean of the Nashville School of Law, where he's done an absolutely phenomenal job. One thing about Dean Koch that we owe a special thanks to is he's going to leave us, drive to Nashville tonight, and early in the morning catch a plane to London, where he will be at the opening of the legal year in England. So please join me in welcoming and thanking Judge Bill Koch.
Thank you so much for that introduction, and I'm amplifying tonight because I have a kind of scratchy voice, so I hope you all can hear me in the back. I'm delighted to come on down I-65 to Birmingham. I don't get to do it as often as I'd like to. It's a two-way road, though, so for any of you that are looking for more construction cranes than you have here, we've got our share up the road. Plus the fact that Nashville is now outstrips Las Vegas for bachelorette parties and pedal taverns and scooters, which I don't believe you've been afflicted with yet. So if you want a glimpse of the future, come up and see what's going on and come back and say, we're not going to do that. I also want to bring you greetings from the approximately 40,000 active members in the 30,000 active members in the 400 American Inns of Court all over the United States and in Japan and Guam. There are American Inns of Court in Japan and Guam. And one of the reasons why I joined the Inns of Court, and I suspect many of you all as well, is that the legal community is quite large. Some to the point where we kind of lose our individuality. The American Inns of Court are a smaller community where you have an opportunity to get to know other professionals in a way you would not necessarily do that outside the context of the inn. And the purpose of this organization is simply to pass down principles involving ethics, professionalism, and excellence in the practice of law. Our organization doesn't take political positions on controversial issues. We're talking about taking a position on the independence of the judiciary. We don't view that as a partisan issue. We view that as something that's very important to the rule of law and to our country. But the American Inns of Court primarily exists to help all of us be better at what we do. Now, when I was invited to come down here tonight, I was very eager to do it, and I asked, what do you want to talk about? And they basically said, what do you have? And I said, well, I can build something if there's something special people want to talk about. And the response was, well, what do you have? I said, well, I can do a really good hour on the rule against perpetuities. And they said, please don't. And I said, rule in Shelley's case, no. I said, and I've written some opinions about that. I am an authority on the rule in Shelley's case. And they said, no, we've taken care of that by statute here. It's not going to be much. And so I said, well, how about ethics? And I said that with trepidation because there is a requirement in Tennessee every year that all of us get 3 hours of CLE in ethics. They're the hardest hours to do. Lawyers always save, come to get their ethics credits in December before the end of the year because they would be rather nailing a nail through their hand than ethics. And so I am going to talk about professionalism and ethics, but I'm hoping to do that in a way that when it's finished, you won't be walking out of here saying, that's an hour I'll never get back. Now, so my goals are very low. I would also have to tell you is that to get ready for this, I had to spend some quality time with your rules of professional conduct because they are subtly and in some cases significantly different than the version of the model rules that Tennessee has adopted. So you all will have access to, if you haven't already got it, I've written a white paper that's going to contain the substance of what I'm talking tonight, so there's no need to take notes. You can sit back and enjoy it, sit back and sleep. After about a half hour, though, this is going to get to be very interactive, and I will be calling on people to work through some ethic vignettes that I think illustrate some of the points of professionalism and ethics. But to show you that I understand that might be a challenge, and notwithstanding the dessert that you have out there, I'm going to make the interactive portion of this worth your while. For any of you that are familiar with Nashville, or with the movie Nashville, some of you are old enough to remember the movie, you might be familiar with a company called the Standard Candy Company. The Standard Candy Company is known for Goo Goo candy clusters. So the participants tonight in our interactive portion are going to be awarded Goo Goo candy clusters. Dark chocolate with marshmallow, peanuts, and if you participate and don't want the Goo Goo, then you can give it to somebody who does, and you'll be a hero twice over. So there are Goo Goos later tonight, right? Now, for some audiences, I brought the regular Goo Goos, they're my favorite. There are milk chocolate pecan Goo Goo Supremes that, you know, I figure we're all down on the regular Goo Goo level. We don't need any of these fancy, highfalutin Goo Goos. So these are the regular Goo Goos. All right, I want to start out with an observation about professionalism and ethics that Judge Stephen David of the Indiana Court of Appeals said in an opinion in 2012. They're not optional behaviors to be displayed when we're having a good day. professionalism and civility are the mainstays of our profession and the foundation on which lawyers practice law. So that's my major premise tonight. We're talking about behavior and conduct that we should do all the time, not just when we're on the top. So I'm going to try to do three things in this presentation. The first, I'm going to suggest that in the 20th century and the beginning of the 21st century, there's been an increasing distance between ethics and professionalism, to the point where they've actually been severed when one time they were both sides of the same coin. And we're at the point now where there's really very little overlapping between the rules of professional conduct and professionalism. I'm going to secondly suggest that one of the unintended consequences of this separation has been a change in the public's perception about us as a profession. And the third thing I'm going to suggest is one of the ways to push back against the public perception of lawyers today, the popular perception, is to think more often and more intentionally about what professionalism means and how it manifests itself in the practice of law. So what about the public's perception of legal profession? And this is now the data, okay? Well, in 2002, the ABA did a poll, and what the ABA poll showed was that 74% of the respondents believed that lawyers were more interested in winning than they were in seeing that justice is done. And 69% of them believed that lawyers are more interested in making money than serving their clients. And you can see the rest of the figures there. It's all, does not paint a very good picture. In the handout, you can see the rest of those. We go ahead to 2013, the Pew Research company did a poll, and basically it showed that as a profession, lawyers rank at the bottom of all professions in terms of credibility and trust. And we go ahead to 2018 in the Rasmussen poll, 43% of the respondents don't trust lawyers, and 28 are not sure they trust lawyers. Those numbers are not that good. And then finally, a Harris poll in 2018, respondents, 91% of the respondents felt that legal fees are too expensive, 87% wish there were alternatives to lawyers doing it, and 69% says, well, why don't we go online and get our legal advice that way. That's not very good news either. You know, our customers are not happy collectively. Now, Gallup poll, this just to show you the change, a Gallup poll that was conducted in 1976 rates the honesty of lawyers. And what that poll showed in 1976 was that 25% of the respondents rated honesty of lawyers as very high or high, 26 rated it as very low or low. Scroll ahead to 2018, 25% has slumped to 19% think that lawyers' honesty are high, very high. And the number of people who have a less opinion about our honesty has increased by 2%. So we are eroding, this public perception is eroding. Well, one of the reasons, in addition to whatever word of mouth dissatisfied customers are using, one of the reasons for this problem is the cultural image of our profession in the popular media. And now there are some of you that I'm going to be perhaps introducing you to some new characters or ones you're not familiar with. For some of us old timers with gray hair, we're perhaps going to be more familiar with some of these black and white folks. But for example, when we think about Atticus Finch, even after the publication of Go Set a Watchman, the figure of Atticus Finch, whether it's being played by Gregory Peck or Jeff Daniels, is an iconic figure of somebody that deserves our trust and confidence, right? The line in the book, after the trial's over, after The client's been convicted. Scout is up in the balcony, and her father is leaving the courtroom, and Scout is told to stand up, your father's leaving. You know, that a profound sign of respect for a losing effort. Well, we had, some of you may have seen The Judgment of Nuremberg. We had the character of Hans Rolf that was played by Maximilian Schell in the film account of the Nuremberg trials. Compelling character. We had Chief Judge Dan Haywood, played by Spencer Tracy, in the same movie. A noble person trying to do the right thing under very trying circumstances. And then one of the one-hour television dramas in the late 50s, early 60s, was a one-hour weekly drama called Public Defender. Or, excuse me, E.G. Marshall playing the defenders. That's how I got interested in law in the 6th grade. But then we also had a weekly drama called Public Defender. And that was an honorable profession, people standing up against the might of the state. Ran for about 4 or 5 years. So, you know, people had trust and confidence in what these people were doing. Now, compared to what we have today, you know, we have Law and Order. Jack McCoy is a very sympathetic, fairly accurate figure, but for every McCoy, we've got Arnie Becker from LA Law. I don't know if many of you remember Arnie. We've got Patricia Hughes from, Damages, not a very sympathetic character. We've got one of my favorites, it's one of the few law shows that I'll watch, Billy McBride from Goliath. I don't know if any of you have seen Billy Bob Thornton. That character is a piece of work, but it's pretty interesting. And then, of course, everybody's favorite, Saul Goodman from Better Call Saul. Right? It's really going to make us proud of our profession when we've got people like Better Call Saul as our standard bearers in the minds of the public. So we've got some work to do. And I want to report to you that the American Inns of Court made an effort to try to figure out why television treated lawyers the way they apparently do. And in 2000 and, well actually, before I get to that, we think all that is entertainment, but there has also been a study, it was actually the American College of Trial Lawyers did a study in 2012. And what the college study showed was that the public believed that the ethics of lawyers on television was better than the ethics of real lawyers. Well, that's the American college. Now, of course, that's not true, but again, here's the problem we're dealing with. That some of these yahoos on television, people actually think are performing at a higher level than what we perform. Big problem. So, we're going to talk about why we are treated so poorly in the media. And in 2011, we had a symposium in Washington at Georgetown University and had a panel discussion on the media's portrayal of the legal profession. And we had very distinguished panelists, Senator Fred Thompson, who of course got his start in Watergate, but you know, was a television star in his own right and a pretty darn good country lawyer. He was on there, but the person that we invited to be the mainstay of this panel was a gentleman by the name of Craig Turk. Now, many of you have probably never heard of Craig Turk because you don't look at the credits after the television shows, but Craig Turk is an Emmy Award, Golden Globe Award, Writers Guild Award nominated writer and producer. And his credits include The Guardian, Cold Case, Law and Order, Boston Legal, Private Practice, The Good Wife, FBI, and The Code. He was the only lawyer on Boston Legal's writing staff. Now, you might say, well, where did Craig Turk come from? Craig Turk, undergraduate at Harvard, graduate of Harvard Law School, LLM from the London School of Economics, took a job with big law in Washington, D.C., worked in his firm for 2 months and said, I hate this. I need to do something else. And so he started writing TV scripts at night. And he got a TV script accepted by Law and Order. And as soon as that happened, he gave his notice of his firm, and he's now doing television. So we're asking Craig Turk, oh, by the way, he was also the general counsel for John McCain's 2000 presidential race. So Turk's got around. And so we put Turk on the spot and said, why do you treat us that way? And he just started laughing. He says, you need to understand, we're in the entertainment business. We're not in the documentary business. And he said, can you, he says, I have to produce a show that people are going to want to watch more than Ice Road Truckers on the History Channel. I want them to turn to my show. And he said, can you imagine me writing an hour-length drama series on television about engineers or architects? He said, nobody's going to want to watch it. He said, the reason why lawyers and doctors are featured in television, or the television shows are built around doctors and lawyers, is that the profession they're in is interesting, it's dramatic, it deals with confrontations, it deals with life and death situations. And so it's nothing personal, but we use you all as foils because what you do is dramatic. So, cut me some slack. And so we cut him some slack, and he's now still producing lawyer shows. So the public media has not helped us too much. Well, what about the disconnect between ethics and professionalism? The Code of Professional Ethics was originally promulgated in 1908. None of us were practicing law back then, but some of us may have read the code in our trek in our profession. And that code that had a combination of conduct, rules, and aspirational goals. It contained moral, practical, and hortatory suggestions on how people should practice law. Now, in 1969, the Model Code of Professional Responsibility was introduced. And physically, the professional suggestions, I'll call them, the professional advice, was separated from the disciplinary rules. And so the hortatory aspirational rules were referred to as canons or ethical considerations, ECs, and the rules of conduct were referred to as disciplinary rules, or DRs. They were physically pulled apart. So that was the beginning of the separation in the minds of the drafters of the model rules and the states that adopted them, that professionalism, ethics, two different things. The final step occurred in 1983 with the adoption of the model rules of professional conduct. And those rules removed essentially all ethical considerations and hortatory suggestions on how to be a consummate professional. And what we were left with were a quasi-criminal set of rules. In other words, if you violate this rule, the disciplinary authorities are going to come get you, and your life is going to be complicated. So don't violate that rule. Now, the question was, why did we end up with a set of rules? And Tennessee's adopted those rules. You have a version of these rules. Why did we take the inspirational language out? The goal was to increase the number of lawyers who would be familiar with the rules and would follow them. In other words, we were going to raise the level of profession by raising the floor, if you get what I mean. You know, raise the floor, everybody will have to rise to that level. And so the question becomes, how have we done? Have we succeeded? Have we raised, since 1983, have we raised the level of the profession? And I'd have to say, I'm not so sure we have. I think perhaps it might be charitable to say we're treading water in the minds of our customers. They think we're backsliding a little bit. So the problem, as I see it, is that under the rules as they originally existed, lawyers would ask questions like, well, I followed the ABA rules, so who are you to question the ABA? We were more apt to ask 30 or 40 years ago, excuse me, I'm going to back up. What we ask ourselves today is, what am I allowed to do? If I get in a pinch, can I do it or not? Am I going to get into a disciplinary problem if I do this, or am I not? As opposed to, what should I do? You know, what's the right thing? You know, there are going to be occasions when you're going to want to do more than just the minimum. Or it might be, is it the right thing to do? So we have the lawyer's quandary, how to stump a corporate lawyer, legal versus ethical. You know, it is, you know, we're right now defaulting to the legal side, perhaps not the professionalism side. Well, what are the lawyer's basic duties? Tennessee kept the old preamble to the rules. You all have the newer preamble in your rules. But what your preamble says is that many of our responsibilities are prescribed by the rules of professional conduct, but we're also guided by personal conscience and the approbation of our peers. So there's something more than just the black letter rules that we're supposed to be guided by. And you know, the fact that we are guided by our personal conscience and the approbation of our peers is something that's very, very important, and it is a tendency, I think, to lift things a little bit. Your preamble also says that we know you're going to encounter conflicting responsibilities. The rules provide a mechanism for resolving those issues, but there are going to be difficult issues of professional discretion, and those issues have to be resolved through the exercise of sensitive, professional, and moral judgment guided by the basic principles. So again, professional and moral judgment. It's not just black and white. We are living in gray areas. So let's turn to what we think the current rules provide in terms of our duties to our clients. And let me suggest that there are four general duties. All right. You also have duties to courts and opposing parties. But the duties to the clients include the duty of competence, the duty to preserve a client's private information and to invoke the privilege during discovery and trial when necessary. Third, the duty to avoid conflicts with the client's interests and those of the lawyer and other parties. And then finally, what I call, the duty to zealously represent our clients. And I'd suggest that one of the gray areas that we're working in here is what the duty of zealous representation means. There are some who interpret zealous advocacy as meaning win at all costs. Do everything and anything you need to do to accomplish what the client wants to do. And I would suggest to you, under the current thinking around the country about zealous representation, under the current version of the model rules, zealous representation is no longer a lawyer's duty. Zealousness is used as a description on how lawyers should represent their clients, but they're not saying you must be zealous. And as a matter of fact, what the comment to your Rule 1.3 says is that lawyers are not bound to press for every advantage that might be realized by a client. So in other words, you don't have, the ethics rules do not require you to do anything and everything to help your